Right. Perfect. So, Miss Pugh, Mr. Jeffries has been appointed to represent you. He's trying to get caught up real quickly on all the information and discovery in your case. I'm going to reset your case so that he can get all of that. Once he'll be out there to go over it with you, and we'll see if we can get an announcement for next quarter. I understand. We've had this conversation before. So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through. We'll do that today. If that's what you want to do, we'll get your case set for trial, and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works. Because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury, and it's going to show, and it's just not going to be, usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of options, and we'll go over those as well, okay?
And right from the start, bam, judges.
What you're seeing here is crucial. The judge isn't just lecturing. She's legally required to confirm that the defendant fully understands the risks of self-representation. And notice the tone. Firm, calm, but crystal clear. Judges must ensure that every defendant grasps courtroom procedure, trial rules, and sentencing ranges before waiving counsel. Because if the defendant struggles to understand the basics now, imagine the chaos during a jury trial. Question for you watching. Do you think anyone should ever represent themselves in a criminal case? Or is that just asking for disaster?
Already calling out these vague, sloppy reports. If you've ever seen him in action, you know he does not play when paperwork is lazy. This is your first hint. Today's cases are going to be a masterclass in probable cause breakdowns.
So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right? So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you? Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Let me pull you up here. You go over that again as well. The date of that allegation from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years, as it's a minimum punishment, up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record. Do you understand? What do you not understand about that? I don't understand.
Quick legal insight. Field sobriety tests aren't automatic. Officers must have independent indicators before they ever ask you to walk a line. Watch closely. Judge Feeser is basically teaching officers how to do their jobs correctly on camera.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States, this is the law that applies to your case. So, what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it. That's what a jury's for, right? So, if you say you're not guilty, then you go in front of a jury, and they determine, after they listen to the evidence, you're guilty.
And here comes the turning point. When the defendant finally admits she doesn't understand the punishment range, the judge makes the call: self-representation denied. This isn't the judge being harsh, this is protection. Courts don't want defendants sleepwalking into prison because they didn't understand the stakes. Then things heat up even more when the judge points out how weak probable cause claims can be if they rely only on alcohol odor. That's a massive legal lesson right there. Smell alone does not equal intoxication, and judges will absolutely call it out.
You're not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. You understand that part? Yeah. What do you, yes or no? No, you don't understand that. So, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So, Mr. Jeffrey.
Okay, here comes the tension. Judges absolutely hate when reports rely.
So in the end, the judge keeps counsel on the case, shuts down the DIY defense plan, and reinforces a major legal truth. Court isn't a game, and the rules matter. From intoxication law to constitutional protections, every detail counts. This case is a perfect reminder that emotions, fear, or frustration never beat preparation and legal knowledge. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Only on odor of alcohol. Because guess what? Odor is not equal to intoxication. Tons of sober people smell like alcohol just by being near a bar. Judge is definitely not convinced yet.
This is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal process. This was not meant to be any kind of punishment or follow. So we'll get Mr. Jeffrey, get ready like you would probably to go straight on to jury. And we'll just get it out that way. All right.
This moment is huge. The judge just shut down one of the most commonly misused justifications in DWI stops. Officers often think odor plus admission equals automatic PC, but legally? Nope. Courts need more. Always.